Hello, and welcome to today's session. Learning Outcome, LO4, Understand Recent Developments in Employment Law. Today, we will explore how employment law in the UK is evolving in response to social, technological, and economic changes. Keeping up with these developments is essential for ensuring compliance, protecting both employers and employees, and anticipating future legal obligations. By the end of this session, you will have a clear understanding of the latest changes in employment law and their practical implications for the workplace. The gig economy has reshaped employment status. Key cases like Uber BV Aslam highlight this shift. Workers gain rights such as minimum wage and paid leave. Employers must now focus on the actual working relationship. This change prompts greater scrutiny of flexible work arrangements. Post-Brexit, the UK can amend EU-derived laws. Major protections remain intact for now. Recent updates simplify holiday pay rules. Employers have more flexibility in recording working hours. These reforms aim for simplification but may reduce employee protection. The Employment Relations Act 2023 enhances flexible working rights. Employees can request flexible work from day one. Cares Leave Act 2023 supports workers caring for dependents. Neonatal Care Act offers paid leave for hospital care. These laws promote inclusion and well-being. The Protection from Redundancy Act 2023 extends rights. Employees on family leave have priority for redeployment. This protection applies during pregnancy and after childbirth. Employers face greater obligations to offer alternatives. Non-compliance risks unfair dismissal claims. The Worker Protection Act 2023 addresses harassment. Employers must take steps to prevent misconduct. Accountability increases even if unaware of incidents. Proactive measures include training and policy updates. Failure to comply can lead to higher compensation awards. Efforts to close the gender pay gap continue. Employers must publish data on pay differences. Proposals for ethnicity and disability pay gap reporting are underway. Cases like Astav Brierley expand equal pay scope. This fosters transparency and accountability. The national minimum wage increases annually. From April 2025, new rates apply for different age groups. The age threshold for the national living wage is reduced. Employers must review pay structures for compliance. Non-compliance risks penalties and reputational damage. AI in recruitment and monitoring raises legal challenges. IQ guidance emphasizes transparency in automated decisions. Employees can appeal algorithmic decisions. Compliance with GDPR and Data Protection Act is crucial. Future cases may involve algorithmic bias. The pandemic reshaped employment law culture. Remote and hybrid work became common. Employers must manage health and safety for home workers. Mental health and well-being are emphasized. Legal risks arise if support is inadequate. Employment law will keep evolving with technology. And regulation in HR, pay gap reporting, and flexible work rights are key. Post-Brexit reviews may affect union and collective rights. ESG standards influence employment law. Employers must adapt to these changes. Flexible working is governed by several acts. Employees can request flexible work from day one. Employers must consult before refusing requests. Refusals must be business-related. Failure to follow procedures can lead to claims. Flexible working includes remote, part-time, and job sharing. Compressed hours and flexitime are common. Each form has benefits and risks. The choice depends on the organization's needs. Employers must balance flexibility and operational requirements. Flexible working improves work-life balance. It boosts productivity and retention. Inclusivity and equality are enhanced. Environmental and economic benefits are notable. Employers save on costs and align with sustainability goals. Flexible working poses operational challenges. Supervision and communication need new strategies. Legal compliance is complex. Work-life boundaries and mental health issues arise. Equality and technological concerns must be addressed. Clear policies and manager training are crucial. Inclusive technology supports remote work. Equality impacts must be reviewed. Well-being and engagement should be monitored. Case law highlights the risks of mishandling requests. Monitoring must balance productivity and privacy. Legal frameworks guide lawful monitoring. Employers have legitimate interests, but must be transparent. Employees retain strong privacy rights. The key is proportionate and justified monitoring. Transparency is essential before monitoring begins. Intrusive surveillance carries privacy risks. Monitoring must be necessary and proportional. Secret monitoring is only for extreme cases. Employees have a right to privacy and data protection. Monitoring must not intrude into personal life. Discriminatory monitoring practices are prohibited. Transparency and proportionality are crucial. Employees can object to unfair monitoring. Employers must balance business needs with rights. Data protection impact assessments are vital. Consent is weak, so legitimate interest is key. Data minimization and purpose limitation are required. Monitoring must respect work-life boundaries. In conclusion, we have learned that the constantly evolving landscape requires ongoing vigilance and adaptability. Should you have any questions, you are welcome to reach me by text or phone on 07000 484 361,688. Thank you for your time, and I look forward to our next session.